Good afternoon, I'm your host, Brian Buckmire, here at the Law&Crime Trial Network. Now we've got 2 live trials for you, so let's break it down. So there you're seeing the cross-examination of one of the investigative officers in this case. I want to have Roger P. Foley, who's with us via Skype, join in the conversation. Roger, how you doing today?
Hey, Brian, how you doing, buddy?
Great. So while I'm listening to this, I'm also watching some of our commentary from lawandcrime.com, and I invite any of our guests to definitely go in there and participate. And I'm starting to have the same question that people are having here is, why is it that this officer's investigation is limited to only what is given to him? Why not have it kind of widespread? Why not look under the fingernails? Why not look under some of the haystacks to see, hey, maybe there's evidence elsewhere that might point to the true killer here?
Well, I can tell you, because he's an arrogant police officer, rather than looking at all evidence and looking for additional evidence, he has that mindset. You can tell in his testimony, he's arrogant in the cross-examination. He says that the investigation led this way, but when we heard other investigators over the last couple of days, we heard that there really wasn't any investigation. They didn't secure the crime scene. He went back and took about 11 pictures. That's not going over a crime scene. That's not looking for evidence. That's not looking for tire tracks or other footprints that may not be lined up with the defendant. He had limited information, and rather than say I had limited information, he wants to say the evidence only directs me to the defendant. And it's just arrogance, and it upsets me because there's a lot of police officers that are like that, and I don't know where that mentality comes from.
Yeah, and then the other thing, and maybe this is more stylistic, Roger, and I definitely want you to talk about this. I feel like at times, and I watched this the other day in my office, at times this defense attorney kind of glosses over very big points that he gets to, but he doesn't really drive home on it. I'm bringing up the point of when he was cross-examining the forensic scientist who had done the autopsy. And they said they just did the nail clippings, but they didn't do a gross investigation. And now you have this person saying, well, I know there were defensive wounds, but we didn't really check the fingernails. I mean, that should have its own line of cross-examination that I think would really make this officer, as you're saying, look very arrogant. Like, where is that?
I don't know. I think it is a stylistic issue, Brian. Normally, if I was arguing this, I would break it down to a page of cross-examination questions just regarding the nail clippings. And I would, page by page by page to each topic that's important so that the jury follows, the witness follows that's on the stand, and everyone's on the same page. I can only think that this particular attorney is going to close everything up in his closing, because sometimes as defense attorneys, we don't want to go all the way. We want to lead the jury right to that spot, but then tell them what we think it is in our closing, rather than asking an officer a question that he can deny or change the footing that we may have at that point. So it could be just a stylistic issue.
Yeah, I hear you. I was always taught in law school, you never want to ask that final question. In the Mullis case, we're taking a short break. But while I've got you here, Roger, I want to ask you a question or two, because like I said, yesterday I was watching this and I was listening to and watching some of the message boards that I saw, and there was a few interesting alternative facts, or alternative theories here, sorry. Joy Hobbs said that maybe the married lovers framed the husband, and in Jules B. actually had an idea that maybe the decedent faked her dizziness, went back to meet the lover, and then was killed by the wife. It seems like people who are just watching this case have a lot of alternative theories as to innocence. Are we seeing a theme that's coming from here? Because we haven't quite heard what the defense theory is as to the defense here.
I think that the reason why we have all these questions is because the state hasn't linked up. They just closed their case. So we have, as attorneys, we have questions. The viewers have questions, and I bet you those jurors have questions, because we have a dead body. It appears to be a murder, but we have a father who's spending time with the son, who's in a barn 30 yards away. Even if he left to get a glass of water or something, he would have heard a scream. If she would have fallen, he would have heard her scream. So it leads me to believe that there's something else going on. And when there's holes in the state's defense, in the state's case in chief, that leads to an acquittal, because there's reasonable doubts of how it could have occurred.
Okay. We're going to jump live into court. The defense is moving for a dismissal based on the lack of evidence presented. So let's take a listen to what they have to say. So Roger, very interesting. I've seen very few trials, and if you've seen more, please let me know, where you actually win on these judgments. But what was curious to me was the judge's explanation for it. His explanation didn't hold enough water for me. What did you think?
You know, most of the time a JOA is denied, right? Because it's in the light most favorable to the state, to the government. So you have to assume. The only problem that I saw with it is that one of the witnesses that they're talking about is a state witness, right? The son. And it sounds like from some of the testimony is conflicting, right? Because the officer, that detective that we just talked to, John Turquette, he's saying, if you believe him, insinuating that he doesn't, that he thinks that he's lying for his father. Do I think that there's enough evidence for it to go to the jury? I do. Is there enough to convict? At this point, I don't personally think so, but I could be wrong. I'm just watching from the stands.
Yeah, and to our viewers, especially on the Law and Crime Trial Network website, who are saying, hey, this is not enough, this is not enough, you've got to remember the hurdle by which you have to overcome at a JOA is about here. And beyond a reasonable doubt is much, much higher. So the difference between those two hurdles is really the difference between a not guilty and just passing through this threshold. I mean, they may put on evidence themselves, they may not, we don't know. But it'll be very interesting to see how this case goes. But I don't see a smoking gun.
That's the problem with this case. I mean, it's strictly a circumstantial case. And the distance, everyone has to look at, right? You have a father-son relationship. Could the son have done it and the father's protecting the son? Could the father have done it and the son been protecting, the father? We don't know. When we don't know, that's reasonable doubt. I think that's what your viewers are at, and I'm right there in agreement with all of them.
Absolutely. I know, Roger, you maybe have one or two of these cases where if I've had husbands or wives or fathers or mothers kind of quote unquote fall on the sword for their loved one. I don't know. Maybe Todd Mullis is falling on the corn rake for his son on this one. We don't know. But we're going to continue.
You couldn't blame him if he did it.
Exactly. Well, we're going to continue more with this case and others after this break.